Mr. Speaker, I will respond to the arguments that have been made by my learned colleagues for the governor, and I am the only member of the team for the Assembly that will respond to those preliminary issues. Mr. Speaker, I am grateful for the opportunity to respond to those preliminary issues. I shall constrain myself to the time that Mr. Speaker has gladly extended our way. Mr. Speaker, I wish to start my response to those preliminary issues by stating that a preliminary issue, by definition, must be an issue that goes to the ability of this House to entertain the motion before it. It cannot be an issue that is merely important to the governor. It cannot be an issue that is merely important to the governor. Sorry, I cannot see my time. Thank you very much. It cannot be an issue that is merely important to the governor, and the governor then chooses to bring it forward and deal with it as a preliminary issue, and it does not go to the ability of this House to hear the motion before it. And, Mr. Speaker, it is settled that a preliminary issue assumes that the facts are settled. Mr. Speaker, the consideration of what the Governor's Council purports to be a preliminary issue involves the detailed consideration of evidence. I was constrained to stand up on my feet and object whilst my learned colleagues were on their feet, because it was apparent that what my learned colleagues were doing for the governor was leading evidence. They were testifying. They were referring to contested statements in the bundles of both documents, and there are responses from the County Assembly in respect of those statements. And those statements must be tested by way of cross-examination. And only once the evidence is laid before this House and it is tested, like the Assembly is entitled to do, then can this House make up their minds as to whether or not those issues hold any water. I am not saying that this House should not consider those issues, but what I am saying emphatically is that this House should not consider those issues as issues that are preliminary to the determination of the motion. There are issues in the motion, and I will demonstrate in a moment how those issues are indeed issues in the motion. I will choose, or I have chosen to respond to the issues that were argued by my learned colleagues for the governor, using a slightly different framework from what they did. We distilled 3 or 4 issues from the notice of preliminary objection that was served on the Assembly, and I wish to crystallize the first issue I wish to respond to as follows, Mr. Speaker. That the governor challenges the validity of the impeachment motion in light of the declaration by the High Court of Kenya sitting in Meru that the impeachment proceedings are a nullity. It is correct, as was submitted by Mr. Ongoya, that it is not contested that indeed there are orders that were issued by the High Court of Kenya sitting in Meru in respect of these proceedings. But what is contested, and I doubt we will agree on this, is the effect of those orders on these proceedings. Mr. Ongoya and his colleagues say that the effect of those orders on these proceedings is to invalidate them, and this Senate should therefore down its tools. We disagree. I submit, and I wish to submit, Mr. Speaker, and emphasize that elections to offices, such as those occupied by the members of this House, are conducted by the people of Kenya in furtherance of primordial sovereignty. Mr. Speaker, the exercise of removal of an elected official, such as the removal of a governor, is therefore, in my submission, the flip side of that exercise of primordial sovereignty. And as authority to my submission, I wish to refer, Mr. Speaker and members of this House, to the provisions of Article 1 of the Constitution. Mr. Speaker, Article 1 of the Constitution provides as follows at Article 1.1. It states that all sovereign power belongs to the people of Kenya and shall be exercised only in accordance with this Constitution. That is an affirmation of sovereignty by the people of Kenya, and it is clear where the sovereignty lies. Article 1.2 then goes on to say that the people may exercise the sovereign power either directly or through their democratically elected representatives. The important provision of Article 1, which I wish to emphasize, is the next provision. Mr. Speaker, sovereign power under this Constitution is delegated to the following state organs, which shall perform their functions in accordance with this Constitution. Parliament and the legislative assemblies Parliament and the legislative assemblies in county governments, the national executive and the executive structures in county governments, the judiciary and independent tribunals. Mr. Speaker, the function of the removal of the governor is delegated to the Senate of the Republic of Kenya by virtue of Article 1.3. The election of the members of Parliament, members of the National Assembly, members of the National Assembly, members of this Senate, and any elected office is done directly by the people of Kenya. Mr. Speaker, as I have said, impeachment is the flip side of election, and it is done again here by the people's representatives. And here I wish to emphasize this point. Mr. Speaker gave a correct and appropriate direction at the beginning of these proceedings that voting on this motion is by delegation. Voting on this motion is not by all members of the Senate, but it is by delegation. And I submit that that is in recognition of the special role, the special function that this House is being called upon to perform when you sit to consider the motion for impeachment. It is not legislative, but it is delegated, and the House has correctly interpreted that role as being exercisable only by delegations and not by all members. Mr. Speaker, it is my submission that a correct interpretation of the doctrine of separation of powers is as follows. Mr. Speaker, and it has been held not just by this House and not just by the High Court, the Court of Appeal, and the Supreme Court, that the role of the judiciary in examining impeachment proceedings arises or kicks in once the impeachment proceeding is complete. Yes, the judiciary has a role, but the judiciary then, as has been correctly held, does not have the ability to intervene at every stage. In our written submissions, Mr. Speaker, we have referred you to the relevant decisions of the Court of Appeal. We have referred you to the decision of the Court of Appeal in Kawira Mwangaza and the decision of the Supreme Court rendered earlier in the matter of Martin Nyaga Wambora. And I wish to suggest a reasoning, perhaps, why the law is as it is. Impeachment proceedings and many proceedings under our Constitution are time-bound. And if judicial intervention is allowed in some of these time-bound proceedings as they proceed, it is not clear whether the judiciary has the ability to suspend constitutional time so as to allow the judicial proceedings to proceed, or whether it is better off to allow the impeachment proceeding to proceed and be completed. And then what is taken is a process review of a completed proceeding to court. What am I saying? The correct interpretation of the doctrine of separation of powers, and it has been held repeatedly by this court, by this Senate, and by the courts, is that even where an impeaching assembly is making a mistake, allow it to complete the mistake. And what is then justiciable is the completed mistake. Don't interfere in between because of timelines, and that, I submit, is a modern interpretation of the view of the doctrine of separation of powers as to how it applies to the power of legislative assemblies, county assemblies, and this House